Thank you, Mr. Shima. With that, I would ask the attorneys in 121504 State v. Reynolds to please come forward. And as soon as you are settled and comfortable, you're welcome to come to the podium.
Madam Chief Justice, and may it please the court. I am before you today respectfully requesting Mr. Reynolds' convictions be reversed. First, the aggravated burglary instruction given to the jury was broader than the crime charged, necessitating a new trial. Secondly, the jury was instructed on 12 alternative means of aggravated burglary and 2 alternative means of aggravated endangerment of a child, but there's insufficient means to support each alternative theory, violating Mr. Reynolds' right to jury unanimity. And third, the cumulative effect of these errors also deprived him of fair trial. And for these reasons, we respectfully request this court vacate Mr. Reynolds' convictions and remand for a new trial. And at this point, I would like to start with the aggravated burglary and charge and instruction, dealing particularly with the overbreadth, then moving into the alternative means of the aggravated burglary and then the alternative means.
Well, let's set
yes.
that up then.
Mm-hmm.
I understand that this was as a result of a grand jury indictment, and the charge there, well, just cut to, didn't mention dwelling. Is that what you're stating? And then the jury instruction then includes aggravated burglary means either a building or a dwelling. Is that what we're getting down to?
Yes.
Let me just ask
yeah.
you, didn't you or your client and counsel actually submit this very instruction that was given?
They did.
And this was after obviously after the indictment, after the charging document, but they submitted an instruction that reflects what was given to the jury.
Correct.
Okay.
But I think that, you know, again, that's not a great look when I'm up here arguing about a jury instruction, but I think that also overlooks the point that the defendant has no ability to charge. And in fact, the state, once you put an indictment through a grand jury pursuant to 2231 or 3201E, you can't amend an indictment because that limits amendments to complaints and informations. And under 223015, you can't amend an indictment when the amendment changes the substance of the charge. So here, regardless of what is in the defendant's jury instructions, is really irrelevant because we're talking about what the state charged. And the defendant has no ability and has no impact to charge a different crime than what the state charged. Now, the state, they charged a crime. They need to go through and go to trial on the crime they charged. They can't change the crime that they charge through the instructions. And in this case, this isn't a small amendment. This changes the target crime from a level 5 to a level 4. It's a completely different element. And as we also accept, it's an alternative means issue. And furthermore, the big prize, there's simply insufficient evidence of the theory of aggravated burglary that the state charged.
Say that again. There's insufficient evidence
of the aggravated burglaries charged by the state.
Part of the issue when it's limited, when it's pared down to an element that isn't included in the indictment or in the charge is kind of surprise, lack of preparation. And I'm wondering how you would respond to the fact that you submitted an instruction that included dwelling. How were you surprised or unable to prepare your defense?
Because again, I'm not focusing on the notice provision. I'm focusing on the state charging a crime and proving that crime. Again, pursuant to the instructions, and particularly because this went through the indictment process, had the state stuck with the complaint that they initially filed, because remember, the state charged this twice this way. They filed an initial complaint, and then they substituted the indictment for the complaint because Shawnee County does this. But so, I mean, they've been through this twice. So again, we're not talking about defendant and inviting instructions because the defendant can't invite a brand new charge that it was charged with. This is the state's, really the only entity that can charge is the state. And so given the nature of the charging document and the power that comes from it, and, you know, identifying the power to charge from the beginning, the jury instructions aren't time for that. And again, we have all our other cases where we have Crosby, we have Hart, we have Trotloff, we cite to Booker that goes back to 66. This is just error. The state needs to be more careful when they charge. In fact, that is the primary function of the district attorney from where I sit, is going through the evidence and picking the crime. It's not hard. It just needs to be done correctly, or else we have a problem. And if there is a problem, the way to deal with this isn't by the jury instructions. And so really, yeah, we had that instruction in there, but I submit that is irrelevant for what any error occurred, because it's not our job. It's the state's job.
So it seems like you could look at this two ways. That number one, you're arguing this is a sufficiency of the evidence issue, correct?
Correct. Well, once we get to the alternative means, that's kind of where I folded that in, because there was nobody in the building. So we don't have an aggravated burglary of a building, but when building or means of conveyance are all that's charged, that becomes a sufficiency evidence if the sufficiency is limited to what the state charged. Now, the reason why we don't have a sufficiency issue that I raised like that here is because then it was expanded. And I didn't feel like it was going to be a smart idea to just ignore the expansion and put all the eggs in the overbreadth basket in case I lost that.
Okay, so what I don't understand is, so you're bringing this as a challenge to a jury instruction.
Correct.
Okay, not as a sufficiency of the evidence.
Correct. Because again, as the jury was instructed, there was sufficient evidence going to the dwelling. But if we limit the charge to what was charged, there was insufficient evidence. And again, I looked a lot in preparing for this case and yesterday's case as to like sufficiency evidence versus the charge and the complaint. And really, there's not a ton of good answers out there, and it's really kind of difficult, and it depends on the case. But here, I think where we have a case where the jury instruction is improperly broadened, if this court wants to find insufficient evidence, then it would be double jeopardy to send it back for a new trial on this because they didn't prove what they charged.
Okay, so let's talk about the jury instruction issue. You have 5807B 1, 2, and 3, dwelling, building, vehicle, and then you have the definition of a dwelling in 215111K.
Correct.
Dwelling is defined as a building or portion thereof intended for use as human habitation, home, or residence. Why isn't, this, the fact that they entered through I don't know whether it was a basement or a first floor?
It was a business. It was a hair salon. It was a portion of a building not intended for human habitation and therefore a building. Because again, when we look at means building or portion thereof. So if the portion of the structure you're in is not intended for human habitation, that structure is not a dwelling, but everything else is.
Okay, what about then my home office?
Your home office.
Is that a dwelling? I mean, how?
Yeah, okay. So here, it depends. And I'm explaining because it can be kind of tricky. And again, a lot of these changes have been changed with the recent amendments to the burglary statute, where now they have different subsections for a locked portion within another portion, which would cover this. But in your case, I don't know what your home office is like, but I'm going to draw a hypothetical. Let's say your home office is in the top floor of a home and there is one front door, right? You have to go through a dwelling to get to the office, okay? I think if somebody were to break into your home office, of course they would have committed a dwelling burglary because they had to do that to get to your home office. Now, again, whether it's one burglary or two, we can discuss that later, but they had.
You can get from the basement or wherever this beauty salon thing was. I mean, there's access to, you just go upstairs and that's where they live, right?
Right, but here's the thing. When, in this case, there was a front door to the salon, door separating salon to the house. There was also a separate front door to the house, okay?
Right, but in my house, I have a mudroom.
No.
And there's a separate door where the mudroom is, and my office is right off the mudroom.
Sure, but I think that would cover the habitation, home, or residence. This salon portion was not a home or residence. It was a business. And so when Mr. Reynolds went through the salon, he went through the salon. There's nobody in the salon. Mr. Reynolds committed a burglary of a building. There was no aggravated burglary because there was nobody in the building portion. So really what the state should have charged here, could put on my prosecutor hat for a little bit, what really happened here, and the most specific, is a burglary done with the intent to commit an aggravated burglary done with the intent to commit the crimes. But when you fold the burglary and the aggravated burglary together, you're destroying the element between the building and the dwelling, which again, 511K or 5111K and 5807 make clear that buildings and dwellings are mutually exclusive.
What about entry? If we take your position, then is it aggravated burglary of a dwelling when he walks upstairs through the door into the home?
Absolutely, absolutely. And the state could have charged that and the state could have left that there. You don't have to charge every single iteration of every single crime. But where the state messed up here is one, is they didn't separate out the target crimes and we have insufficient evidence of the criminal threat. But
You're not taught, so here, I'm having a hard time distinguishing between, you keep bringing in insufficient evidence, but when we use our jury instruction analysis, it says in a building or dwelling, that's what the jury instruction says.
But a building or dwelling are two different crimes, and that's the alternative means
How
problem.
can that be when dwelling is defined as a building?
But a dwelling, but it's not. It means a building or portion thereof that is used or intended for human habitation or home residence. So imagine I'm out on the farm and I've got my combine shop, but I have a small room in the back where I keep a cot where I can go sleep on long summer nights. And somebody comes in and steals my anhydrous or steals my tools. Have they burgled a dwelling? Absolutely not. Now, if they go back there and I'm sleeping there and I'm using that place at the time and they break into my individual place I'm using as a home, because what you're doing
It's a question of fact for the jury about whether it's used primarily as a home or a business?
no, my main argument and my primary argument on the dwelling and building is that they are mutually exclusive by statute. If you look at 5807, building, manufactured home, mobile home, tent, or other structure which is not a dwelling. So any structure not a dwelling or means of conveyance is two. And again, we look at the definition, building or portion thereof of an enclosed space that is used. So again, only the portion that is used for human habitation when you have a mixed use structure.
Counts. And I'm interrupting, I'm sorry, but I want to, at least for personal questions,
Yeah.
grant you the
no,
distinction
sure.
you're
Yeah, thank
drawing.
you.
I think I understand that. But where I'm confused is in the legal theory that you're presenting to us. Because I've understood this issue to come to us as essentially an alternative means claim,
Mhm.
which I've always understood to be essentially a subspecies of a sufficiency of the evidence
Mhm.
claim. But I'm hearing you say this, you're just bringing a jury instruction.
No, I'm not. I think where I said that is I thought we were talking about my overbreadth challenge that I raised in issue 2 of my petition. I'm talking about first and not my specific alternative means challenge.
Because if,
I mean, I think we're kind of blending.
would you
those,
agree
yeah.
with me that the traditional alternative means challenge essentially says, look, if we don't know that the jury was unanimous on the specific means, then we can't affirm the conviction unless there's sufficient evidence.
No, correct. And that exactly. And that's what I'm trying to get to. And that's why I'm focused on the building, because I'm saying that the jury was presented this option of an aggravated burglary of a dwelling
Then we
or
have
of a
to,
building that they can't find. So then we have to go back for
then
new
we have to
trial.
apply a sort of super sufficiency test, right?
Yes, my answer is under the super sufficiency test that fails because there was no person in the building. So we have to go back.
Okay, so it is a sufficiency challenge.
It is.
Okay, so
It
that leads to my actual question, which
Yeah.
is, should the super sufficiency analysis contain a harmlessness element to it?
Absolutely not, Your Honor.
Why not?
Because one, first off, this has been the law for as long as I've been practicing law in this state. And so I think to change it now, we would need a good reason. The only reason I've seen proffered is a 10-year-old law review article that's been cited numerous times and forgotten. And secondly, since we've had our super sufficiency thing in place, the US Supreme Court decided Ramos v. Louisiana. Because remember, at the time that we did super sufficiency, it was still a little bit of an open question as to whether or not a unanimous jury verdict was even constitutionally required given Louisiana and Oregon. But now since that question has been answered, I think departing from a super sufficiency analysis would just be contrary to the movement and the reinvigoration of unanimous jury verdicts as indicated by the US Supreme Court.
I have a question
Mhm.
about, to push back a little bit on your position that you.
Mhm.
ASA 22-3015 states as follows, under subsection A, matters of form, time, place, and names. At any time before or during trial, the court may, upon application of the prosecuting attorney and with notice to the defendant, an opportunity for the defendant to be heard, order the amendment of an indictment with respect to defects, errors, or variances from the proof related to matters of form, time, place, and names of person which, when such amendment does not change the substance of the charge and does not prejudice the defendant on the merits. On ordering the amendment, the court for good cause shown may grant a continuance, etc. That appears to allow an amendment on the indictment if if the change is to place and there's not prejudice to the. What's your best argument that in the course of the orders that were made, that didn't happen or couldn't happen?
I think it's still that same subsection of the portion of when such amendment does not change the substance of the charge. And here, the change of inserting the dwelling raises this from a level 5 to a level 4. It's a different element. I think that that is a substantive change that 3015 clearly says you can't do.
I'm not finding a definition in the jury instructions for building or dwelling. Am I missing something?
I will check during my colleague's presentation, but I can't recall if there was a definition given.
Yeah, I had to
And
look
does-
somewhere else, but yeah, go ahead.
Okay. Does that end up mattering on your overbreadth argument, at least as to what the potential remedy might be, in that to me, if the jury hasn't been told about the special legal definitions, a common sense definition would be that you have this umbrella term, building, and a dwelling can be a subset of that. And so it may make a difference in terms of the severity level. I could see your argument there, but does it have any deeper harm or require any deeper remedy than that if the jury was just using a common sense application of the definition of building and dwelling, which in their mind could have, under these facts, essentially been synonymous?
Yeah, I think I certainly agree that that makes the situation more harmful and even more difficult than, as previously thought. I think that, to the extent that that could also impact cumulatively other error going on to this. But again, I think that given this, that, yeah, you're right. And I should have probably said something about that earlier now, but if there is no definition given, particularly given the way the specificity of this, that is just one more infirmity onto this aggravated burglary instruction that, again, I don't think that there is any way that we can say with any confidence that we have a constitutionally valid unanimous decision on a version, and that just makes it even worse. So again, I just think that that just kind of dog piles on to the harmfulness here and why we need a new trial on this issue. Or a new trial on these issues, because it just simply wasn't fair. And I just want to note just one last minute, and I see I'm out of time, but I know that the state thinks alternative means are difficult, and you're like, well, what do we got to do? We can't really tell what the jury
And
does.
would you address that? I was going to
Yeah.
ask you, and before you sit down, you are out of time, but I did want to address. The Court of Appeals essentially found that the actus reus is the entering or remaining within. And the various means by which that occurs, either to a dwelling, manufactured home, a portion of any building, are just the options within those means. What is wrong with that analysis?
So
Or is it's,
yeah.
and I appreciate it's a close call here, but what's
Sure.
wrong? with
Well,
that?
so I think a couple of things. First off, I think with the Court of Appeals enter and remain an analysis is infected and incorrect due to their building dwelling analysis, because they found that once a building and dwelling are the same structure, then yeah, he entered and remained in both, when in reality, he never remained in with the building because he went straight through into the dwelling. So once you get that distinction, you get the enter and remain. And then again, with the target crimes, this court, the Kansas Court of Appeals, have always treated these as alternative means. And I think this court needs to, because when we look at Brown, the alternative means come down to whether or not the legislature listed two or more distinct alternative means, i.e. mens rea, actus reus, and sometimes causation. But when we import an entirely new crime as the target crime, you're necessarily importing totally new mens reas, totally new actus reus, and sometimes even causations.
And
So
so the importing of the new crime is the fact that severity level is greater for a dwelling than a building. What's
excuse me, sorry, I'm not sure if I'm quite following your question there.
you said that they imported a new crime.
No. Sorry, that was just misspeaking. Is when you change the target crime, the enter remain with the intent to X. Anytime you change X, you're necessarily putting a brand new set of elements, maybe a new mental state, maybe new causation element in front of the jury, such that. And again, one thing just to talk about avoidance, which I started when I asked for extra time. Avoidance of alternative means. There are 12 versions of alternative means burglary in here, by my calculation, because you got the where, the building dwelling, the what, enter remain, and then the why, the intent, i.e. kidnapping, prim threat, ag assault. Nothing prevented the state from charging 12 different alternatives. So that way we had the jury to answer each discrete group of elements.
Well, speaking of the different alternatives, with respect to the actual evidence that was produced in front of the jury, there any chance any juror thought, based on the evidence, that there was a person in the salon?
I can't say, I'm not a juror. And again,
I'm asking you to evaluate the evidence.
Mhm.
And can you point to anything in the evidence which could lead a juror to a reasonable conclusion that there was a person in the salon?
Absolutely not, which is why it
And
falls under alternative means.
Doesn't that suggest that we know with a certainty that passes beyond reasonable doubt, that no juror thought that this defendant was guilty of an ag burglary of the salon?
I suppose you could do that, but two things. One, that's really close to reweighing the evidence. And frankly, anytime you have a guilty verdict, and that same argument could be made. Well, they found it, couldn't we also find it? And secondly, even if that's true for the building dwelling, that still doesn't get to the unconstitutional criminal threat. That still doesn't get to the acquitted kidnapping. I mean, there are still other problems here. So, but yes, but I guess at bottom dollar, my answer is unanimity is far too important to be including a harmlessness test, especially when the state can charge their way around these problems.
And you mentioned one of your reasons for not departing from that was Ramos v. Louisiana. And that case, it constitutionalized the unanimity issue to the Sixth Amendment. But in that decision, the Supreme Court did not address whether that constitutional error could or could not be subject to a harmlessness inquiry, because the parties didn't suggest that that error could be harmless.
Sure. No, and again, but at the end of the day, I think, the idea of jury unanimity being harmless to me just kind of strikes me as deeply un-American and deeply unconstitutional. And again, that may just be a personal issue, but I just think once we're like, well, 8's close enough. I don't know. I mean, beyond a reasonable doubt, fundamental rights and liberties are at stake. Unanimity is unanimity. That's saying I'm way out of time. I'm sorry. I don't have any more remarks.
See no more questions. Thank you, Mr. Mann.
Thank you, Your Honor.
Good morning, may it please the court. The state again appears by Deputy District Attorney Jody Lippman. We've hit on all the issues except for the aggravated endangering a child, so I guess I'll just go to the aggravated burglary. The state viewed this in two different ways, I guess. There is the alternative means issue, which was raised as the first issue about all of the different means of aggravated burglary. And then we have a separate jury instruction issue. So although they blend together, I guess the state kind of treated them as either we can find that they're alternative means, which we argue that they're not, dwelling and building, as the Court of Appeals, I believe, held, and we can be done with that analysis, or we can go into the instructional error, and then talk about it in that way, the trout loft kind of broader or narrower with the addition of the dwelling in the jury instruction.
I want to let you get to your thoughts because I'm really interested in, but it seems like there's a baseline level of why did the state let this get charged and instructed the way it did? It strikes me that every time we wrestle with these alternative means problems, it's a self-inflicted issue, maybe not an error, but a self-inflicted issue because the state doesn't tailor its case based upon what it's got. I mean, the original alternative means case involved, included a jury instruction on bestiality when there was no animal, on the property, but it was a sex crime. And you just kind of rip the pick instruction and start instructing the jury. So my question to you though, in this case, is there a reason that justifies the way this thing was charged and instructed as opposed to it just being imprecise way of doing it?
Can I point you to a place in the record where I can say why this was charged the way it was and not simply a mistake and dwelling wasn't in there? No. Do I believe though that the parties, when we get to the instructional error part, it seems to me that the parties were on the same page and that no one really noticed that dwelling wasn't in there because there was an admission that he entered the dwelling. I think that defense counsel admitted and no one contested that he entered the dwelling. And again, the instruction did have dwelling. I think that the defendant proposed in it. So to me, it was just, and it is frustrating to get.
I'm not trying to get you to notice. I understand all of that. I mean, really what you're telling me is the state skipped a step.
It's not in the instruction and I can't tell you why. I don't know if it's intentional or to me, it seems more as a mistake because to me, it seems the parties or to the state, it seems the parties did know that the crime really was about a dwelling. And the
But you
defendant
said it's not in the instruction. Did you actually mean it's not in
In
the
the-
charge?
indictment, I'm sorry, indictment, yes. I've had a lot of tongue twisters doing this with all the aggravated and all of the things. So yes, I'm sorry, in the indictment. But if you look at the indictment and go back to it, what is charged is the entire subsection of B, as Your Honor was saying, which includes dwelling, building, motor vehicle, the severity level 4-person felony, which is for a dwelling. So the fact that dwelling didn't make it in, and we haven't talked about the exact address is listed also. So what kind of prejudice comes from knowing the exact address, having the entire subsection of B, and having it be a severity level 4-person felony? So that kind of goes to the prejudice. If we treat this as a jury instruction error, that goes to the state's prejudice
I didn't
argument.
I don't remember from all the reading. Were there two different addresses? And you're saying the address was specified, but were there addresses to choose from?
There were not. It's just one home salon.
One
However,
structure.
yes, one structure. So, and that goes to, again, our prejudice. And this is really, and whether this court wants to buy this or not, the state did argue that this seems more of a, it's an insufficient charging document error rather than a jury instruction error. So we would argue that there was no objection to the indictment or no, complaint about the indictment, and that can be waived. So if this court wants to go that route, that's an option as well. But we want to argue that he's not prejudiced here, even with the inclusion of the dwelling in the jury instruction, because again, it includes several references to burglary to a dwelling. I think I've listed them all, and it lists the penalty for aggravated burglary to a dwelling and that subsection B generally, which lists all three.
Why is it in the jury instruction? Been entered or remain in a building or dwelling? Why is there both building and dwelling contained in that first element of the jury instruction?
That's the pick probably gives options. I didn't look at the pick. I mean, here, I think that's what the state alleged again, and I think that's what the parties were expecting it to be, is dwelling and building. So, I mean, I think I don't know that I have a better answer.
Yeah, well, what's your answer to the fact that those are two mutually exclusive elements to be proven?
I think our position is that we agree with the Court of Appeals and that the burglary building or dwelling are not alternative means, but merely options within a means. And if we look at, it's really the structure. I don't know if we can call a motor vehicle or structure. It's the thing that is being entered into or remained within, that's the material distinct element. And that building, dwelling, motor vehicle, et cetera, are options within a means.
Even though one is a more serious offense.
Yeah, and I was trying to, I thought about that and I was looking at Brown, and I don't think Brown talks about penalties at all. I don't think that comes into play when we're looking at alternative means. I think it's just conduct or different mental states. And I did a bunch of highlighting on the actual crime. And if you look, the only difference between building, dwelling, all that doesn't have to do with the conduct, that doesn't have to do with the mental state, or even there's some causation. And the state's position is those don't have to do, that's not an alternative means as far as conduct, mental state or anything like that. So,
What about just the fact that they're listed in separate subsections?
I
That
think
weighs
that
pretty heavily against your argument.
I agree. I think the state uses that all the time in our favor, and I think it's not in our favor here. But again, I would just hone back into, does it really talk about different conduct, a different mental state that's needed, or a different causation requirement? And we would argue that it doesn't. It just is factual circumstances that establish what is being entered into and remained in within.
If we find that because they're separate subsections, because it's separate crime, that does create an alternative means, what's your best argument that they're, how we get around reversing that? Because there's no evidence that there was a human being present in the building portion of the structure.
I think one option is this court can find that it's just a burglary to a building, because that's a lesser included and you didn't have to have a person present within. I don't remember if I made that argument below, to be quite honest, but I thought of that. Maybe we could just do a burglary to a building and
Well,
then.
maybe, was there a lesser included of burglary?
I don't think so. I don't remember.
So we can't invent a
Um,
lesser included, can
I
we?
want to say there's case law though, that where this court has found that if there was insufficient evidence of ag burglary, then they have defaulted to a burglary. Again, I'm sorry, I don't have that for this court, but I think there are cases that that's been done. But I will jump over to my harm.
They'll lose your ag burglary conviction though. That was the case.
I don't know that we would to a dwelling. If we're just talking about
The problem, if these are alternative means, is that this is the whole rationale behind the super sufficiency test. Courts look at this and say, well, we don't know whether a juror, an individual juror who voted guilty, we don't know whether that juror voted guilty because of the dwelling or because of the building. Therefore, we require that there be sufficient evidence to support both.
right. And we could,
And
if,
so if there's not sufficient evidence to support the burglary of the building, we have to declare insufficient evidence for the entire conviction.
and the state can retry on the one that there was sufficient evidence of. So ag burglary to a dwelling.
But it would still be a reversal. I mean, I think that's.
I don't
just
know if I can
Rose's
get around that.
question.
Yeah, I mean, I think so.
Well, it strikes me the only potential way to get around it is to apply some sort of harmlessness.
Right, and
analysis.
and I can jump to that. I think I made that in the context of the ag kidnapping, endangering of a child claim, but I think it would be applicable to here as well.
Do you agree we would have to depart from existing case law to do that?
Yeah, you'd have to disagree with Wright, which I think the state has been arguing for some time.
You've
and
been
this
arguing
person-
for some time, and I think you brought it up in your last brief. Didn't you file a supplemental and you spent a paragraph talking about right? But I don't know if it's in the context of this or the crime you were just talking about. But that's where, and I don't know if that's late. I mean, you really didn't put it before us until
Without having my
much after the fact.
Without having my brief up here, Your Honor, I think I did raise it in the aggravated endangering of a child issue in the original brief, I believe. And I believe I maybe just expanded on it a little bit in the supplemental brief. So if I'm wrong, I am, but I want to say that I did raise it at least in that issue in the original briefing. And I would just point this court to Hedge Path. And I don't know about that. I'm sorry, I don't know if it wasn't mentioned or if I just missed it, but I didn't know about the Ramos versus Louisiana case. But But I would point the court to Hedgepath, which talks about juries being instructed on an alternative theory, which was an invalid one, and that this court, or that the court can find a harmless error analysis under Chapman for a constitutional issue. So we would assert that that supports our position here, and that there is some justices who have suggested that they would be willing to do an alternative or a harmless error analysis in the alternative means context as well. I think that comes from State versus Dern. And we would also argue that.
What would that look like? What would the legal test for that look like? Would it be something akin to, we are convinced there's no possibility of juror confusion on which means they were voting guilty on?
Yes, yes. And I don't know if it would be like, I think in the prosecutorial error standard, it's a Chapman analysis where the state has the burden to show that the.
But what is it we would be looking at? Is it juror? I mean, I used the word confusion. It's not exactly right, but are we trying to ask the question, could a juror have found guilt on the means for which there is insufficient evidence?
Yeah, no reasonable probability that the
It's
jury
like
would have found.
Justice Biles referenced the bestiality case earlier, where you look at that and you just say, well, no juror would have thought that, because it was just simply, it's not that there was insufficient evidence, there was no evidence.
Yes. And just like here with the permitting, there's no evidence of permitting. So yeah, I think that this court could have confidence in a harmless error test such as that, to know that the jury is presumed to follow the instructions. The instructions say to base it off the evidence that was presented, and if there is absolutely no evidence, which is why it may not be might not be harmless in every case. But here, I think we have a good example of why it could be. And with that, I don't think I have any further presentation. We would just ask that this court affirm the Court of Appeals decision and affirm the convictions in this case.
It please the court. I actually do not have any more presentation. I just came up because I told you I would look. There were no definitions given to the dwelling. I do not know why. But if there are any other questions, I would just. Yeah.
The state, I'm looking at my notes. It appears to me that they brought up the harmlessness question that we were just talking about in a conditional cross petition for review.
No, I checked that. That was also in their brief of the appellee. I don't remember if it was in the child in danger protection, but it is in there. It is in there. But I guess, well, I'm happy. I would just caution this court to not accept a harmless error test to alternative means. We've been there. We've gotten rid of that. This has been the long-standing law for over a decade, almost a decade and a half now. And at the end of the day, anytime we're starting to figure this out, the state can, one, really think about their charges, narrow them down, and make sure they have sufficient evidence of only one charge. Two, if they're unsure, separate the alternative means into alternative charges. You can charge 12 different versions of count 4, and this problem disappears. And 3, and even if this court were to not accept those two, we get into really dangerous territory of reweighing evidence and figuring out what a jury must have thought or would have thought or would have done. It's just much easier to make the state prove it to a jury the first time and a second time if necessary. And with that, I have no more remarks. Thank you.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this case under advisement.